Lawyers of Reddit, what's the most ridiculous argument you've heard in court? As a corporate lawyer, the most ridiculous argument I come across almost monthly is as follows. Fortune 500 company signs a garbage contract and is going to lose a lot of money due to the plain language of that contract. Fortune 500 company argues unconscionability. Specifically that said company was not sophisticated enough to read the contract, and no reasonable person would ever agree to the term or terms in dispute. In sum, multi-billion-dollar firms claiming they are incapable of reading contracts. How often does this work? Never on those facts. I have never made an unconscionability argument, and I often represent clients that don't have high school educations. The standard I often hear is that the result must shock the conscience in terms of unfairness to the plaintiff. I work for a Fortune 500 oil company. We are incapable of reading contracts from what I've seen, even the ones we've written. Fortune 500 companies are filled with so many morons in the legal department that I don't even know where to begin ranting. One example, Fortune 500 company A wants to wind up a subsidiary of Fortune 500 company B because company B hasn't paid an acknowledged debt, the recovery of which is barred by limitations. A thinks it will get the debt amount this way. It will not, because clearly a civil suit isn't maintainable. Law student, former professor's story. Defendant busted for possession of narcotics. They were in the pocket of his leather jacket. He argues the search was illegal because with his buttery smooth leather jacket, there's no way the officer would have felt the drugs in his pocket during a pat down. So he shouldn't have reached in the pocket to find the drugs in the first place. Judge asks if the jacket is the one he was currently wearing in court. It was. Judge asks to feel this jacket in the pockets. Defendant hands it to the bailiff. Judge finds more drugs in the pocket. Needless to say, it didn't go well for him. Out of all of the comments I've read, this one is my favorite. The sheer stupidity you would need to have to not only bring drugs into a courthouse, but also hand the jacket with the drugs over to the judge. He should be studied. Haha. Did he really say, buttery smooth? That's the way my professor told it, so as far as I know, yes. This sounds similar to the not my pants defense we hear from indigent clients all too often. Amazing how many people put on someone else's pants on the regular. I was a juror, but this was a heck of a defense. Defendant ran through a red light and crossed against traffic in front of an officer. She was over twice the limit. It wasn't her fault. She had a cut on her arm that her dog licked. The yeast from the dog's saliva entered her bloodstream and converted her blood sugar into alcohol. Is that even possible? If it is possible, we sure as heck didn't hear from any experts during trial that said so. The defense was just trying to cast reasonable doubt. If there is yeast in dog saliva, it makes sense it might produce some alcohol, but so tiny and insignificant that it wouldn't begin to make her drunk. A drop of beer on your tongue would probably get you more plastered. It probably wouldn't even survive long enough to reach her brain. Points to her for creative use of chemistry, though. Sounds like the argument worked better as a start of an insanity plea. While deliberating, we sort of just looked at each other and said, how long do we have to sit in this room? So they feel we gave this some thought. It wasn't long. Oh geez. Where do I start? I mean, I could tell plenty of these about my own clients, but I like this one. A lady has an injury/compensation case. It's for her upper back and of course complex regional pain syndrome, CRPS. She decides she needs the insurance company to pay for a special mattress for her, like a $6,000 memory foam with heat and massage and 1,000 other features. And not just a twin, she needs a California king, because of course her layabout unemployed boyfriend needs to sleep there too. We spend months litigating this dang thing. Finally, she buys it herself, and my client agrees to give her $1,500 just to be done with it. The judge takes myself and opposing counsel aside and says he's gonna do muss if we ever say the word mattress in his court again after wasting all this time. It was that ridiculous. Not 3 months go by and the case comes on for another hearing. After exhausting all the chiropractic care allowed under the law, her doctor was seeking a variance to get some additional chiropractic. We get to court, and I'm arguing it should be denied, etc. Judge turns to her and says, "Ma'am, why do you feel you need more chiropractic care?" She pauses for a minute then says, "I'm having a lot of trouble sleeping on my mattress. I think I saw smoke coming out of his ears. Isn't CRPS the most painful condition known to man? Now I kinda feel bad for her. Yeah, and insurance companies should pay for these things. That's kind of the point of insurance." I have a brief encounter, personal injury prospect. Old lady slipped and fell on an icy driveway, which was not salted or maintained. So she wanted to sue for damages. After hearing the story, turns out the lady fell on her own driveway, which she did not salt/maintain. She was wanting to sue herself. Who did she think she was suing? Homeowner's insurance policy. I suppose there is some logic in that. Not much, but some. That lady that got all over the news cycles a while back for suing her nephew actually was forced to do something similar to get the insurance to cover her injury. I remember getting so annoyed until I read all the reasons why. It was literally just an administrative thing to name a party to have insurance foot the bill. Again, it's just like a famous Paralympian in the UK was forced to sue her friend's dad after becoming paralyzed in a pool accident. She was broadly vilified for doing so, even though she had to eliminate him as a responsible party. A few years later, and she was the darling of London 2012. Girlfriend is a Reddit lurker. Posting on her behalf, this is a story that my grandpa always tells, so some of the details are fuzzy but this is the gist of it. My grandpa was a public defender, and this was a defense he used for one of his clients, who was being accused of attempting to break into a car. How it happened: man number 1 is sitting in his house, and he looks out the window and sees man number 2 next to a car parked in the street. Man number 2 is out there fiddling with the car door for like 10 minutes, and so man number 1 realizes he's trying to break into the car and calls the cops. Man number 2 runs, and eventually man number 3, my grandpa's client, is picked up nearby because he matched the description of man number 2. So my grandpa is meeting with his client and telling him what he's accused of. Client asks, "Wait, what kind of car was it?" Grandpa tells him. Client says, "I can prove that it wasn't me." Grandpa, "How?" Client, "You said the guy was out there for 10 minutes. I can break into that car in less than 20 seconds. Grandpa, "Prove it." So he finds one of whatever kind of car it was, and the client proceeds to pick the lock in 12 seconds. Grandpa gets the judge out there, and the client does it again for the judge, who makes him do it one more time, and then dismisses the case. I expected a different outcome. This thread is about stupid court claims, not genius ones that actually work to get the case dismissed. Technically it's the most ridiculous argument in a court. "I'm far better at being a criminal, so it couldn't have been me" is a ridiculous argument. It just happened to work. Recovering small business/BK attorney here. Was in bankruptcy court on a motion of my own when a very young attorney gets up to argue his position. His request was denied in pre-hearing disposition. Young attorney: "YA, Your Honor, I believe your reading of the 3 cases you have cited is incorrect." Bankruptcy court judge: "BKJ, you think that, do you?" YA: "Yes, Your Honor. I don't think the bankruptcy appellate panel believed these cases would be used in this fashion, and I think you are misreading the author's scope." BKJ: "Okay. Tell me, as those are BAP opinions. Who wrote those opinions?" YA: "I'm not sure, Your Honor. I didn't check." BKJ: "In the future you may want to check those sorts of things. All 3 cases were authored by the judge you just told didn't understand his own writing." Court audience: mostly attorneys. Collective gasp. YA: "Blank stare." BKJ: "Facepalm. Geez, son. I wrote those opinions." YA: "Oh, well I still think they are wrong." BKJ: "Request denied. Get the heck out of my courtroom." It was, quite possibly, the most awkward type of walk of shame I've ever seen as he gathered his things and left. The most impressive part for me is that this poor guy actually got a judge exasperated enough to say, "Geez, son. Agreed." And the facepalm isn't just a storytelling device here. He quite literally had his hand on his forehead, looking at his bench while saying it. It was great. Thanks for watching. If you enjoyed this video, please consider leaving a like and subscribing for more videos like this. Don't forget to leave your stories in the comments below.